Hi, welcome to the second video about the Baker Act process. This is going to be a quick video about what law enforcement's role is and just a couple of tidbits about when somebody is Baker Acted and the initial steps. So let's get started. When the Baker Act is initiated, law enforcement will transport the person to the receiving facility. Part of law enforcement's protocol is to handcuff the person, even though they are not being detained or arrested. Unfortunately, this does include children. This is for safety purposes, no other reason. Remember that law enforcement is trained to respond to dangerous situations. They are not trained to be therapists. And it is not their intent to make a bad situation worse. When law enforcement actually initiates a Baker Act, sometimes it's done in the place of an arrest. When this happens, I encourage the individual to move into gratitude rather than to stay in anger, because a 72-hour hold is significantly better than having to deal with months and possibly years of the consequences of being arrested. Also, once law enforcement drops an individual off at the receiving facility, they no longer have control over what happens. When law enforcement tells an individual that they only have to go to the facility for a couple of hours or maybe a day, they are actually making a true statement. It is up to the facility to determine if a longer stay is needed and appropriate, or if they are going to exploit a situation for financial gain. A common misunderstanding is when the 72 hours starts. For clarification, the 72 hours starts once the admission process at the receiving facility is complete. Typically, there is an intake process which includes paperwork, a nurse evaluation, vitals taken, their belongings being inventoried, etc. Once the person is being escorted to the room that they are going to be staying in, that's a safe time to actually start counting the 72 hours. Another common misunderstanding is that once that process is complete, that the evaluation is complete. However, the way the law is written, it allows for up to a 72-hour time frame for the evaluation. However, the Baker Act also specifically states that when a person no longer meets the criteria that I spoke about in the first video, that they must be released. It does not state that the person has to wait for outpatient appointments to be made. I will discuss this again in the next video when I discuss the difference between voluntary and involuntary status. So, because this is an involuntary commitment, it is an enforced hold, which means that the person cannot release themselves and just walk out of the facility. They can only be discharged with documented approval from a psychiatrist or a clinical psychologist. In the next video, I will explain more about what is supposed to happen during those 72 hours and some things to watch out for. Stay tuned for some key suggestions on how to advocate for yourself or on the behalf of a loved one. Remember that information is power, and it improves our ability to advocate for proper treatment and discharge. So, if this information has been helpful in any way and or interesting, please hit the like button below and share this video with your family and friends. Please include any questions or comments that you might have in the comments below, and I will respond to the best of my ability. I appreciate any and all feedback. And please don't forget to subscribe. Thank you for watching, and I wish for each of you to be strong and be well.